Welcome to the Ayn Rand Fan Club. I'm Scott Schiff along with William Swig. William, how are you today?
I'm doing well. How are you?
Good, good. Well, I'm very pleased. We have well-known libertarian, retired patent attorney, author, and longtime Ayn Rand fan, Stephan Kinsella. Stephan, thank you for joining us today.
Glad to be here. Very glad.
And before we get into all the IP stuff that I know is going to come up, can you just give us a little bit about your background story, even how you got into Ayn Rand and
Sure.
libertarianism?
Yeah, sure. I'm a mostly retired patent attorney here in Houston, Texas. I'm from Louisiana and I'm 59 years old, and so I was raised up in the 70s and 80s in Louisiana. And I was always philosophical, and I was into technology and all that and science fiction. But in high school, I was at a Catholic high school in Louisiana, Baton Rouge, and a librarian who knew I liked literature and reading and philosophy recommended that I read The Fountainhead. That was like 10th grade. So I read The Fountainhead and got hooked and got really interested in objectivism and philosophy. And I would say I was a hardcore objectivist for about 8 years. I still consider myself to be an objectivist if you go by the four main tenets. They probably wouldn't have me, but I do subscribe to her four main tenets in general terms. Egoism, reality, capitalism, individualism, that kind of stuff. I agree with all of it, still do. Um, Self-interest. So,
Fantastic.
but then of course that led me to Mises and Rothbard and the the anarchists, and so I became way more interested in say around law school and college time in Austrian economics and anarchist theory. So I kind of shifted to anarchism around that time. And when I started practicing law in 1992, I started in oil and gas law at first in Houston, but then I switched to patent law soon after that for career reasons. And when I did that around 94, I also, or 93, I started thinking, I was writing also on libertarian topics like rights and stuff like that. So I thought maybe I'll turn my attention to the intellectual property issue because everyone else's treatment of it was dissatisfying to me, like Galambos and Spooner and Rand and the utilitarians, everything there was something wrong with all of their approaches. So I thought because I'm a patent attorney and I'm a budding writer, libertarian writer, I can figure it out. And I was trying to justify intellectual property for a couple years, reading everything I could, and finally I realized why I kept failing, and that I was trying to justify the unjustifiable, to use to mangle a Walter Block type of title. And that it was the reason I was failing and the reason that I was dissatisfied with all the arguments was that it was unjustified. So I came to that conclusion right around the time I started practicing patent law. So, for my whole career, I was increasingly opposed to the patent and copyright system while I was doing it for a living. So it was kind of a
Did that
weird.
affect, did judges know your view? Did you practice in
Well,
front of
it,
judges?
it, at first, I kind of tried to downplay my opinions. Like, I mean, I would write on this, like as a hobby, on libertarian journals and editorials and things like that. And then for my job and my career, I would write legal articles and things like that. And they were sort of separate, but I was a little bit worried that the word would kind of get out, that I was an anti-IP patent attorney, and it would hurt me with my partners and my clients. But of course, no one reads anything and no one cares about, it'd be like me worrying that they would be worried about my religion or my sexual preference or something, that no one cares. And they don't read anything. And not only that, I found it, so I started becoming more vocal when I realized it wasn't hurting me. And in fact, I would speak up among lawyer groups and they would just listen, but they weren't interested. But it started getting me clients. So I would go to like the Mises Institute and give a speech why the patent system should be abolished, and someone would walk up to me and they would say, "Hey, I've got this idea for an invention. Can you help me with it?" I mean, they didn't care that I wanted to abolish the system. From their point of view, I was a smart patent lawyer who knew the law so well that I knew it should be abolished, but I must know it well enough to lecture on it. So I must be competent at my job. So let's hire Kinsella. So it just strangely never hurt me. So
Were there
Um,
any other attorneys who felt the way you felt?
I've identified a few. I mean, one of my good friends, who I was a lawyer with, he's sort of a default libertarian, and he's a cynic about the whole thing. He thinks it's BS, but he doesn't write on it or anything. And I've had a couple people, they would write anonymous letters to me. Like they write me a letter and they'd ask me to post it anonymously because they were kind of afraid it would hurt their careers. Um, like there was one law professor who died, but he was anti-IP, but he was a socialist, so I didn't like to count him on my side. But yeah, there was a couple that were anti-IP. But everyone who's pro-IP, it's just like when you talk to a post office worker or a teacher at a public school. They're in favor of the post office and the public schools, but they don't really have a good argument. They're just in favor of it because it pays their check. Most lawyers and patent lawyers don't think about it. They just, I mean, they might repeat the talking points like it's good for innovation, but that's not why they do it. They do it for a paycheck, you know. But yeah, I've come across a few that agree. In fact, my old boss, my first patent lawyer boss, Bill Norvell, I reconnected with him about 6 months ago after like many years, and he's retired, and he agreed to come on, and I interviewed him, and he told me he agrees with me that the patent system should be abolished. I'm like, really? He goes, yeah, I read your stuff. You think you're right? I was a little surprised. So, yeah, I've seen that from time to time.
And just for our audience that may not be aware, can you just give us a quick synopsis? I think I understand where you're coming from, but just
Sure,
the
sure.
briefest.
Yeah, and so, and we can talk if you want about the problems I've seen with it and where I think the error lies, like why people get this issue wrong. It's hard to disentangle because it's confusing. And then the second question, why I think objectivists get it wrong, and that's a harder one to figure out. I've been trying to find a way to articulate what the exact error is that objectivists make on this issue.
But I mean, it's broadly in the public. I think most people have just accepted patents and
Correct.
copyright, but
So the broad, yeah, but the objectives try to have a more intellectual argument based upon their theory of rights, and I think that's flawed in certain ways. But the standard, okay, the standard argument, there's sort of two main arguments for intellectual property. Well, one is just that it's in the Constitution, so if the Constitution says we should have patent and copyright law, then we should have it because it's in the Constitution. That's sort of like an argument from authority or from tradition or just from that we've always had it. That's not really a good argument. I do think that's why Ayn Rand was in favor of it, by the way. She was such a fan of the Constitution and the American system that, and she hated the Russian system that she assumed that the US system was so good that she had to find a way to justify the patent system that was in the Constitution. Plus, she was a writer, so it kind of went along with her career. But the main argument
Can I
people,
jump in real quick there? Because
yeah, yeah, sure.
so I reread Patents and Copyrights by Ayn Rand, and
Hmm.
I think she had a little bit more sophisticated argument than that because she thought that, and I'm quoting here, the government does not grant a patent or
Yeah,
copyright
yeah, yeah.
in the sense of a gift, privilege, or favor. The
Yes,
government merely secures it.
correct.
So I think her idea was that you have this right based on your actions or your nature or whatever you've been doing. And
Yes,
so it's not a privilege, but
I
it's
totally agree. Yeah,
okay.
that's definitely her view. I mean, I think that was her. I don't want to be unkind and say her rationalization, but that was not in the Constitution, right? That was her attempt to show why that law is just, even though the rationale in the Constitution is explicitly consequentialist or utilitarian. It says to promote the progress of the arts, Congress can grant these limited monopolies basically for a limited time. So that was an explicitly consequentialist or utilitarian goal. Now, one of her followers, Adam Mossoff, a law professor, has tried to put her arguments on a little bit sounder footing, and he's also argued, like Rand did, that the common conception of patents now and copyrights as being utilitarian is wrong, that it was a natural right. So that was her view. No, but I think he's just wrong as a matter of history. His view is that Jefferson and the founding fathers and even John Locke, these guys really didn't view it as a monopoly granted by the government or a privilege. They viewed it as a natural right. although there's of course confusion by them because they weren't perfect objectivists or whatever. But he thinks that their view is that it was um, a natural right. Now, that's just a historical dispute. I think they're wrong. There's a guy named Ronan Deasley who's written on this. Like John Locke did support copyright, but only for um, to stimulate like the arts and stuff like that. I don't think John Locke himself even thought that there was a natural right to intellectual creations, although that's debatable. But anyway, that's ultimately an argument from authority. Anyway, but basically the argument is that you would have an underproduction of innovative works and creative works, like artistic works that are covered by copyright and invention, which is covered by patents, if you had kind of if you didn't have the government grant these limited rights of patent and copyright, you would have an underproduction of works because it would be too difficult for them to recoup their cost of development, because when they face competition from people copying their inventions or their works, they wouldn't be able to make a profit as easily, and they wouldn't be able to recoup their effort. And so you need to grant them these temporary monopolies to make sure that they can sell their products at a higher price for a temporary time, make enough profit to justify them doing it in the first place. So that's sort of the utilitarian or consequentialist argument, which is sort of implied by the constitutional clause. But the second way of looking at it is that it's a natural right, and that's the idea that you have a natural right to things that you create. Um, and so then the government just secures those rights, which is sort of how Rand tried to put it and how Adam Mossoff tries to put it. That's the kind of the standard view. And the view I came to is that both of those arguments are confused and wrong because well, utilitarianism is not the way you justify laws. And number two, there's no evidence to support their case. And then on the natural rights side, that there's a confusion about the nature and origin of rights. Basically, the mistake came because of a flaw made by John Locke in his original argument, which he had to introduce because of the way he had to argue against the theistic arguments at the time. And he introduced this idea of labor ownership, which I think is the mistake, which crept into later political philosophy. And I think it corrupted the way we think about the origin of rights. And it led to what I call Lockean creationism, the idea that creation is the source of rights. And I think it also led to Adam Smith and Ricardo and then Karl Marx's labor theory of value. Like it's this whole misconception about value and whether it's an ownable thing and what role it plays in the acquisition of rights and in the production of wealth. But we can get into that if you want. But that's kind of my view about why. And so ultimately, the problem I have with patent and copyright is that they violate property rights that are already granted in material things based upon homesteading and contract. So if you have ownership of an object like a printing press or a factory because you built it yourself or because you acquired it by contract, that property right should allow you to do whatever you want with that resource unless you're committing an act of aggression. And that was basically inherent in Ayn Rand's view of what aggression was, right? That only the initiation of force can be prohibited by law. And unless you're initiating force, no law is just that stops that force. And my argument is that so once you have a domain of property secured by contract and by original appropriation, that determines who owns that resource. So I can use my factory to make a copy of an iPhone and sell it, or a copy of a book and sell it because I'm just making something with my own property and I'm not committing an act of aggression. I'm not initiating force against anyone else. And so ultimately those laws grant the right to the holder of the patent or copyright to stop me from using my property as I see fit. It lets them limit how I can use my property, even though I didn't commit an act of aggression. So it's what I call a negative easement or a negative servitude that the state grants to someone that I didn't consent to. It's a burden on my property that I didn't consent to, unlike a voluntary negative easement, like a homeowners association restrictive covenant where you agree to not build a house over a certain height or whatever. those are contractual and they're fine because the owner consented to it. But in the case of patent and copyright, the owner doesn't consent to a burden on his factory or his printing press. The government grants it to someone else by fiat. So it's a non-consensual, it's an involuntary negative servitude. And that's ultimately the problem with patent and copyright is they are takings of existing property rights.
My
What do
wife
you,
summarized your view as, you can't tell me what to do with my printing press. That
Correct.
and but within that, I mean, you know, can I open a hamburger place called McDonald's and put golden arches outside and like piggyback off of their reputation?
Well, so we could talk about that. It's important to get these things distinct. So in the beginning, there was no such thing as the concept of intellectual property. There were patent and copyright, which were created by statute. They were not common law rights. Now, there were also other things now called IP rights, like trademark and trade secret, which evolved on the common law. And let's forget about trade secret for a second. You don't really need the government to give you a right to have a trade secret. You just have to keep it secret. So that's just if you own your head and you're not compelled to speak, you can keep information secret, really. But trademark is it started in the idea that if you use a brand or a mark to identify the source of a good, that others can't use a mark too similar because that would confuse consumers, which is kind of close to fraud. So the original justification for giving a trademark right to someone to enable them to stop someone else from using a similar name was based on the idea that, well, other people shouldn't be defrauding consumers. Okay. So that's rooted in the idea of fraud, which you could justify slightly, unless you understand the details of the way trademark works, in which you realize that if that's really the basis of trademark, then you don't need trademark law. You already have fraud law and contract law. But let's just set that aside. The point is, and by the way, the Constitution in the U.S. doesn't give Congress the power to regulate trademark. It only gives them the power to regulate inventions and artistic works, which is copyright and patent, which is why the original two IP laws were patent and copyright in 1790. And it wasn't until the 1950s when state law is what governed trademark law and defamation law and fraud law and contract law and trade secret law until then. And so the federal government passed the Lanham Act in the 50s, or maybe it was even later, I can't remember. And they federalized part of trademark law under the Interstate Commerce Clause, which I think is clearly unconstitutional. But anyway, so my answer is actually, I do think that people should be able to make a golden arches and compete with McDonald's for two reasons. Number one, it's not a right of McDonald's that's being violated. It's the right of consumers who are being allegedly defrauded. And if you make a fake McDonald's chain and you defraud consumers, then I think they should have a contract or a fraud claim against that fake McDonald's, and they would sue them into oblivion and they would just go out of business. It just wouldn't be a real problem. But the point is, the right shouldn't be the right to McDonald's. It should be the right to the deceived consumer. And the second thing is, trademark law now does not require you to show fraud. It only requires you to show the likelihood of consumer confusion. And it doesn't even require that if it's a famous mark. It only has to show there's a dilution of that mark. So trademark law has really turned into a reputation right like defamation law. So for example, if someone sells knockoff Rolex watches or knockoff Chanel purses and they sell them for $20, out of a van on the sidewalks in New York City, then Rolex or Chanel can get a court order and they can go seize those products and have them destroyed. But on what grounds? The people buying it are not being deceived. There is no fraud. There's no consumer confusion whatsoever. No one buying a $20 Rolex watch thinks it's real. So the only harm done is to the reputation right of Rolex or Chanel, but that is not a trademark right. That's a reputation right, which is and we can get into, that's a whole nother issue. I think the objectivists are also wrong to believe in reputation rights. David Kelly supports reputation rights. I think that's wrong.
But you're
I
using
think
reputation rights for part of this argument for why you would be able to sue them or
no, I think you could sue them for fraud. Fraud is a different thing. So I think fraud law is justified. Fraud means when you deceive someone and you basically take their money by trick, right, or by deceptively. So basically, it's like a case of there's lack of informed consent. I've written there's a whole chapter in my book on libertarian legal theory. This is my book. It came out 2 years ago. This has all my arguments in it, legal
I think you
foundations.
said it's not copyrighted.
Well, it's copyrighted because all copyright is automatic, but I have a Creative Commons zero license on there, so I've made it public domain as much as the law will allow me to make it. Um, yeah, I've had 3 or 4 people, smartasses, they'll say things like, this is you get there's so many bad arguments for IP. You'll have someone they'll say, oh well, Kinsella, well they'll first I get the hypocrisy argument. Oh, you're a practicing patent lawyer, so you're a hypocrite. I'm like, well, so basically the only people you want to complain about IP law are people that don't know anything about it. Because if someone knows something about it, like me, we're supposed to not complain about it. So, and anyway, whether I'm a hypocrite or not is irrelevant to whether IP law is justified. You know, like they do this kind of dishonest argument. But I'll have people say something like, "Oh, well, Stephan Kinsella, I guess they don't know that my works are open source." So they'll say something like, "Well, I guess Kinsella wouldn't mind if I slapped my name on his book and make $1 million." It's like, do you idiots know how hard it is to make money selling? I mean, do you really think if it was so easy to make $1 million selling a 75-page book on IP law that I wouldn't have tried to do that already? Go ahead, show me how to do this, you know? So what I've done is like they'll say, "What if I slap my name on your book?" That's the thing. Slap my name. Like, okay. So I'll take like my article, I put their name on it, and I put it on my website. I'll say, "Here it is." You know, John Dokes is against intellectual property. Congratulations. Now you've just published a book arguing against patents with your name on it. Is that what you really want to do? I mean, like it makes no sense. These guys are just smartasses. I forgot where I was going with that, but
I'd like to
it made me
ask you
yeah,
a question about the effect of the division of labor on
yeah,
the need for patents and copyrights. Because,
yeah,
like when we were just hunter-gatherers, I mean, there's no need for any patents or copyrights because there's no technology, that's going to make them money. People aren't publishing books and things like that. But when civilization reaches the point where you need storytellers and you
yeah,
need inventors and
yeah,
they need to be able to make money and survive in society
yeah, yeah,
off of their labor.
yeah.
And so isn't patents and copyrights a form of um, protecting the division of labor and
Right.
the need for that?
Well, that's complicated. I mean, so first of all, the way I look at it in general is I hate to bring up praxeology and Mises, but it's a simple way of looking at what human action is, and I don't think this is incompatible with objectivism. In every action in human life, human beings aim at a certain end. They're trying to change the universe. They're trying to change the future from the way they see things coming, right? They're uneasy about what they think is coming, and they have a goal in mind and they try to achieve it. That's what all human action is. To do that, they have to have knowledge and they have to have scarce resources at their disposal, right? The knowledge is the ideas, and that's crucially important. And that's an ingredient that you have to have for successful action. You also have to have availability of means, and to have availability of means in a society of other people where there's possible conflict, you want to have secure possession of those means so that people don't take it from you, so you can have long-term plans and things like that. So property rights emerge to socially protect those scarce means of action, but the knowledge is the second ingredient that informs what you do. And so I would say even in the even in the caveman days or the days you're talking about, technological knowledge is equally important. You have to know how to catch a fish, you have to know how to do things. And so if I don't see why you wouldn't, if we need IP now, I don't see why we wouldn't need it before. I mean, just because it wasn't that In fact, there's like back in Sybaris, the Greek city-state in the year 2500, about 500 BC, 2,500 years ago, there was some crude early forms of copyright and patent where there was a culinary competition, and so everyone would try to cook their best dish, and they would have a competition, and whoever won, who got the king's favor or whatever, would have a monopoly to be the only one who could make that dish for a year. Only they could make it. It was sort of an incentive to do that. So you had this idea around for a long time, but the idea, there's two problems with the way you worded it. Number one is it presupposes that the purpose of rights and property rights is like we have to have this sort of central planning mentality and look around for market failures and things that the law should incentivize or encourage. Like we need to make sure we have enough division of labor or something like that. And that's just not the purpose of law and of justice and of rights. The purpose of law and is to protect people's rights, to do justice, right? And to do that, we have to know what their rights are. And then once their rights are established, then they can operate knowing what they are, and then it's up to them to figure out how to make a profit in a world that secures those rights.
But
And then
going,
and then one more thing. Then the other mistaken assumption is it assumes that you need to have the government grant you some kind of limited protection from competition to sell something or to make a profit at it. I mean, you can sell a book without having the right to stop people from selling copies of the book. There's nothing stopping you from selling your book. But go ahead.
yeah, I was just going to say, I mean, the take that incentives don't matter versus the rights. I mean, going back to Rand, it's like the moral is the practical, and you can see
Agree.
that in all these areas
Agree.
that capitalism increases the rate of technological progress, standard of
Agree.
living. And
Agree.
so you're telling us here in this one case that within adopting it, it may stifle creativity or the
Yeah.
arts.
Yeah. Well,
And
so the way I would say this, I would say that I agree with Rand, and I don't think that it does stifle creativity, and I don't think it's necessary. But I'm simply saying that our primary focus has to be on the principled approach and on rights. Um, and you don't reverse engineer the rights to get the incentives that you want. Normally, they go hand in hand. Okay. And if you can say, well, the rights system that Kinsella proposes has this breakdown because there's no good incentives, so there may be something wrong with it. That's fine to point that out and to look at it closely and see if there's a disconnect, because there shouldn't be a disconnect. There's the practical and the moral should be the same thing. I think that the assumption is wrong, and in fact, all the empirical studies show that every argument given that you need these rights to stimulate creativity, and that without these rights, you have an underproduction of these things, a so-called market failure. There's just no evidence of that. The common sense case, I understand the common sense case, like, well, why would I spend $1 billion to make a drug that someone could just make a knockoff of the next day? Like, I can understand that kind of knee-jerk argument. But if you look into it more closely, the argument just fades away. And in any case, the point is you have to first identify what our rights are, um, and and uh, and then you have to analyze how society is going to work based on that. Um, but I'm not saying that I don't care what happens or that the consequences are irrelevant or incentives don't matter. I do think that incentives matter, and I think they flow from a rational, objective system of law that protects property rights. I just think that it's enough to do that, and that within that system, people can find ways to make a profit, even though they face competition. Basically, I don't have a problem with competition, which is ultimately what people that support patent and copyright have a problem with. I think that this kind of goes along with Williams' idea about the modern age versus the caveman age. I think people have this idea that up until around, say, the 2000s, maybe, when the internet started and technology started and piracy started and encryption started and digital information started, up until that age, we were in the analog age. And in the analog age, you had a natural you had a natural ability to make a profit because it was difficult for people to compete with you. Because everything people made was a real service or a product, a tangible product, a material product, which required a factory and employees and capital and labor. And when you invest in that and you take a risk and then you hope to make a profit and you start making a profit, you make sort of an unnatural profit for a while. Because remember, profit is an unnatural thing because when you make a profit on the market, you send a signal, a price signal to the rest of the world saying this guy's making a lot of money. He's doing it by pleasing the consumers. And over time, you attract competition and it becomes harder to make that profit. But for a while, you have a head start and your profit goes down to the rate of interest over time. But at first, you have this natural, not a monopoly really in a legal sense, but you have a natural profit in the beginning because you're the first one. But then over time, that gets eroded and you have to keep improving your product. But that's the natural way the world worked in the analog age. When there was sort of a friction or a difficulty of people right away competing with you, they couldn't like if I sold a Harry Potter book on one day, or if I sold a new phone on one day, or a new drug, people couldn't make a duplicate of it the very next day because even when books were analog, you had to have a printing press. You had to decide which books to copy if you want to pirate or bootleg books. And so you don't want to copy every book that's out there because you might be wasting your money. So you want to wait and see what the bestseller is, right? So you might wait a year or two to see, oh, Harry Potter is the bestseller. Now I'm going to start making bootleg copies. But in the digital age, you can do it right away. Or I can make a drug right away is the argument, which is not true. It's not the way pharmaceutical companies work. But anyway, that's the idea is that it's too easy to compete in the digital age. And because it's too easy to compete, the natural analog world's competition process breaks down. And now it's too easy for people to compete with you. It's too hard to make a profit. It's too hard to make this unnatural profit. It goes down to zero much more quickly, and therefore the whole incentive structure breaks down. So we should put these patent and copyright laws in place to they literally say this, to slow down the diffusion of ideas because these new ideas are a problem. I mean, I think it's insane, but that's kind of what they come out on. So basically they're literally afraid of competition because competition makes it if competition comes too free and easy, which it does in the digital age with certain goods like digital goods, then no one's going to invest in the first place. That's kind of the argument.
I'd like to try to get at something maybe more fundamental.
Yeah.
I watched your intellectual property and history course on
Yes.
YouTube, and you were discussing different types of property, real property, personal property, and
Yes.
intellectual property. Um, why can't the arguments for real property be applied to intellectual property as
Right.
well? It seems like in both cases you're mixing some
Right.
mental effort with physical things.
Right.
So I'm curious, like, what your thought is on that.
Right. And I got sidetracked the way I do. You asked earlier about patent and copyright and fraud and all this. And so the reason I distinguished patent and copyright from trademark was, I think, Scott, you had asked, well, if someone makes golden arches and all this, that's a trademark example. And what I was going to say is originally people viewed and thought of and called patent and copyright, they called them monopolies and monopoly privileges. Uh, Thomas Jefferson, when he was in Paris, when the Constitution was being uh, drafted, or the Bill of Rights, one or the other, I can't remember. He wasn't really part of that process, but he had some correspondence with Madison I think it was when the Bill of Rights was being drafted. It was after the Constitution had been drafted and ratified in 1789, and it had the patent and copyright clause in there, granting Congress the power to enact um, protections for inventions and authors for a limited period of time. It said that. Jefferson suggested in the Bill of Rights, putting one of the Bill of Rights, he thought it should be a more explicit limit that, and Congress can only grant these monopolies, and I think he used the word monopolies and he put blank period for blank years. Like he wanted to put a cap in there, but the point is he called them monopolies. And the other point is that he wanted to put a cap in there, just like when the income tax amendment was being debated in the early 1900s. I think one of the congressmen wanted to put a 10% cap in there, But the other congressman said, no, we can't put a 10% cap in there because Congress will think that we can go to 10% right away. They'll think we're giving them permission to go to 10%, which would be ridiculous. Of course, now we wish they had put a 10% cap in there, and I wish they had put a 14-year cap, which was roughly Jefferson's idea. If we had put a 14-year cap in the original Constitution and the Bill of Rights, patent and copyright would have had to expire in 14 years, and they wouldn't have been able to go for 150 years like copyright does now. But anyway, so the argument has been made by people like, so one more thing. So originally these things were recognized to be privileges. And then in the 1800s, the free market economists started criticizing patent and copyright, which is becoming more of a noticeable thing after the US enacted these laws based upon the original British system of which was based, by the way, on a law called the Statute of Monopolies and the Statute of Anne. They were that was the patent and copyright statutes. It was literally called the Statute of Monopolies. But the free market economists in the 1800s, like in 1825 to 1850, they started objecting to patent and copyright because they recognized they were monopolies and they were in restraint of free trade and international trade. So there was a growing movement for people for these countries to start abolishing or not adopting or slowing down the adoption of their patent and copyright laws. But in response, by this time, you had these publishing industries and you had some inventive industries emerging, which were now getting dependent on patent and copyright. So they started opposing it, and they said one of their arguments was in response to the criticism that we should abolish these state-granted privileges, these monopoly privileges. Their argument was, well, it's not a privilege; it's a right. It's a natural. They started calling it a natural right. And someone said, well, what kind of natural right is it that expires in 14 years? And their response was, well, it's a special type of property right. It's an intellectual property right. So they came up with the term intellectual property as a propaganda move to try to say it's just another type of property because everyone was in favor of property rights. So if you call it a property right, and that's sort of the argument that goes on now by Adam Mossoff and Richard Epstein and others. They say, well, there's a similarity or an analogy between property and material things and intellectual property. And one argument they make is the one you sort of hinted at is that, well, they're all the product of the human intellect and human effort, and they're all things that you create. So just like you can own a chair or a house that you create, why can't you own an idea that you create, right? Like a book or an invention or a song or something like that, right? And the problem is with that argument is that you don't, this is what I alluded to earlier. The mistake made by Locke is that people have seized on an aspect of his argument, which is the idea that the reason you homestead tangible resources is because you own your labor. All right, that's the argument. That's the assumption. So there's an assumption there that you can own your labor, and if you can own your labor, you can own things you mix with it, and that leads people to believe that the essence of ownership of unowned things or created things is the ownership of your labor that you mix with it. The fallacy there, in my view, is that you don't own your labor. Labor is an action. It's not a thing that you can own, which is related to the problem I think Randians have with their rights theory. They use this word values in an idiosyncratic way. Most people say value is a verb. It's something that you value something by acting to gain and or keep it, which is what Rand used in another context. She said a value is something you act to gain and or keep. But she viewed it as a noun, as an object, as a thing that you create. But in other writings, she reckoned, so I think there's a tension in her writing. So she said that we don't really create things ex nihilo from nothing. We just rearrange matter, which is also what Rothbard and Mises say. The act of creation or the act of production is really rearranging matter into a more useful configuration. And that is a useful thing. It requires knowledge and insight and ingenuity and effort and
But you can apply that to pen marks on a page or art.
um,
In terms of, increasing the value of those physical products.
correct. And that's like Daniel Schulman, who was a libertarian anarchist, but Rand influenced writer. It's funny how all these novelists are in favor of copyright, like Rand and Neil Schulman and L. Neil Smith, even though they're anarchists, they
I
happen to
think
favor copyright.
it boils down to originality, right? Because if you're creating a fictional story, that requires a lot of mental effort to come up with that, especially if it's a
Correct. Correct.
really
It
good
does require
story.
mental effort. There's no doubt about that. But the question is, do you own effort? Do you own labor? Or is it just something you do with your property?
Well, if you think of ownership as taking ownership of what you do, like
Right.
responsibility,
That's a different term. That's
and
a different sense of the term, though. Yeah, that's another
and
confusion, I think. Yeah.
and when you combine that with originality, and also where I was going with the division of labor thing is that you need to live off of this originality. That's your career. That's
Yeah.
the way you're going to make money. It's the way you're going to survive.
Right.
Ayn Rand said you live off the products of your mind as a human.
Correct.
So I think we need to recognize that in some way in
Yeah.
law to protect that so people can live off the products of their mind.
I think that I think a lot of Rand's insights are correct, but some of them are more metaphorical. And the problem is, I think that she didn't quite fully realize that there's really a conflict between. Let me give an example, and I don't want to be patronizing because I look, this stuff is not easy, and I think it's understandable that I think she made a mistake. I understand why. Even Rothbard messed this up too. Um, um, I think all of us would agree, all objectivists and libertarians would agree that there is a mistaken idea that if the government could easily just feed the poor by printing more money. We understand the problem with that argument, right? The problem is that when you print more money, you dilute the value of existing money, right? In other words, it would just be a disguised transfer of wealth from one person to another, right? Um, in other words, nothing comes for free. And the same problem is the case with positive rights, which is why we all basically talk about negative rights. There's a right to have people refrain from violating our rights, but there's no positive rights, which are welfare rights. Because if the government protects negative rights, but it also tries to protect positive rights, you can't do both because the positive rights come at the expense of negative rights, right? If the government protects my right to my body and my car and my house, but it also gives people a welfare right, like to go to college or to have free food or housing or whatever, that's got to come from me because they have to tax me to do it, right? So nothing comes for free. And the same thing is true, I believe, of intellectual rights because they have to come at the expense of existing physical rights. It's not like you can just say, first we recognize real property rights, and then we also recognize intellectual rights by analogy, and we just add on to the rights. They have to come at the expense of these rights. And the reason is it comes in the form of the negative servitude I talked about. Just like your one of your wives says, yeah, it's like telling you what to do with your property. I mean, ultimately, the question is, if I come up with a useful way to put ink on paper, and I turn this paste the stack of paper and ink into uh, into Atlas Shrugged, and I sell it. It's worth more than just the ink and the paper by itself to a buyer because the buyer wants it arranged in a certain way, right? That's Schulman's argument for the identity of the thing is the book itself. It's not it's the novel, kind of this platonic abstract idea of it, and they're just one instantiation of it. And then you should have the right to all copies of the book. But what they don't understand is that's claiming a right in what Roderick Long calls a universal. Look, if you own a car, let's say you have a red car, your car is red, but you don't own that feature of the car, that characteristic or that property of the car. You don't own its redness. Because if you did, you would own every other car in the world or every other thing in the world that was red. You can't own a characteristic of a thing. And the thing is that information is always a characteristic of a thing because information doesn't exist on its own. Like I learned this being a patent lawyer writing computer software claims when I was trying to claim like you can write a patent on an object or an apparatus we call it, or on a process or a method, a way of doing something, right? Those are method claims. But when you write a method claim, you want to in the computer age, you wanted to get a patent on that method, but also on a computer implemented way of doing it. So I would write a set of claims on the method, like a flow chart, but I would write a set of claims on a computer implemented method of doing it, like the computer designed to do these steps, but also on at the time, like a CD-ROM. I would say, okay, a CD-ROM that has imprinted on it the information that would lead a computer to perform these steps. Because I was trying to get a claim, a patent claim that would cover someone selling a CD-ROM at the time that if implemented on a computer would infringe the patent, right? But then we also came up with these claims. We call them signal claims, right? And I said a signal, but that got a little metaphysical because the idea is like, what if I don't, and this is an analog to streaming video games now as opposed to buying a copy of it or streaming music now or streaming movies. I don't necessarily have to have a physical copy of a program that performs these patented steps. I could just have it beamed to me from a satellite over the electromagnetic airwaves, right, in the air. But so you have these digital signals, which don't really exist as a physical thing, but they have a carrier wave. They have to have a carrier wave, which, by the way, I agree with some objectivists. I'm a big skeptic of quantum physics, I'm a fan of them. I think there is an ether. There's no such thing as a wave without an ether, but that's another issue.
Just stuff
Well,
we don't
I
fully
probably
understand yet.
What's
I
that?
probably agree with you a little bit there because I think there is something, I call it just space. I think space
Yes.
is a thing, it's not a thing, but it's like close to the closest you can get to nothing. And it
Yeah.
provides a sort of medium for everything that exists to travel
Well,
through.
well, and my view is I'm influenced by Peter Beckman, who is an objectivist, influenced electrical engineer professor, and his theory is that it's the gravitational field itself is the ether, but that's a whole different
Yeah, before we
issues.
get, but just keeping on technology for
Yeah,
a moment,
yeah, yeah,
is it fair, to some degree, copyright law changes with advances in recording and reproduction? I read the
yes,
1910 copyright law was like partially a response to whether piano rolls on piano players.
correct, correct. The original Copyright Act only covered basically uh, books, basically, and maps, maybe. But and you could argue that modern copyright is unconstitutional because the original clause didn't encompass things like things that are covered now. But the copyright statutes have evolved to cover computer code, and which I think is unconstitutional because software is patentable also because it's functional. It's not really expressive. It's either one or the other. But copyright software code can be covered by patents or by copyright, which makes no sense to me. But um,
Part of my
it does.
concern
Yeah, go ahead.
is just, with AI, for example, are we now stifling what AI can
Right.
do because of
Yes,
all the
I was going to say you said it evolves, but it actually doesn't evolve fast enough because this is a good example. This is a good example of copyright is not free. It always hurts something. It slows down the development of knowledge. Patents are even worse. I think patents do the most damage because the reason the human race is richer now is because we have more technological knowledge at our disposal because every generation or every day we get more and more that people can dip in and use and patents intentionally slow down or impede the development and spread of that knowledge and makes the human race
and
poorer.
Elon's been opening his patents.
Correct. He started that a long time ago because he realized that he needed to open any patents he had to make sure he didn't scare away competitors because he needed to have a bigger market to have a piece of than it's better to have 10% of a huge market than 80% of a zero market. And Twitter did that too a long time ago too. Twitter had an agreement with their employees where they granted the right to their employees to limit the ability of Twitter to use their patents aggressively. Like they tried to tie their own hands. But Before we get further, I wanted to ask you guys. You mentioned to me in your note to me you've been questioning IP yourself. So I'm just curious, what is your take as an objectivist on patent and copyright, and what are the reasons why you're questioning it?
Yeah, speaking for myself, it's things like Elon, going to open source. It's seeing things like how, with Rand, they used to have, $200 tape sets. You had to have all these provisions for exactly how you used it, and you had to
Yeah,
play the whole thing. And then they realized, oh, it's actually better to give the stuff a lot of it away and draw people in that way. And also what's going on with AI. And it's just like,
yeah,
we've got this
yeah,
incredible tool, and it's like
yeah,
all these things. It's like, I'm not trying to make money off of this just because I want to include a song or a picture
yeah.
of something that's trademarked.
Well,
And what,
you should try this. I mean, if you go to Grok or ChatGPT and you ask it like what, like say, recite for me, page 17 of this book. It will come up with all kinds of excuses. If you ask it, why can't you do that? It will ultimately admit it's because of copyright. So the designers are intentionally gimping it, and it will admit that if I was free of copyright, so their training would be better and less distorted, and they could store things and give better answers. It's hard. It's really putting a serious barrier on an extremely important and developing technology. And that's an example of
that's the
why copyright and
utilitarian
patent. Well, it's not
argument.
utilitarian. I don't think. Look, if you say that the drug war destroys lives, that's not a utilitarian argument. It's illustrating the reason we oppose injustice, right? The reason we favor property rights that would not allow the drug war is because if you allow the drug war, it's going to cause human death and destruction and misery. That's not a consequentialist argument. There's nothing wrong with illustrating the negative effects of unjust laws, right?
Right, but I'm just saying that's before we had an issue with whether or not it was actually going to be stifling creativity to have these copyright laws,
Well,
which is
the thing is you don't see there's the hidden the seen in the unseen, right? I mean, we don't know how much technology and how much artistic work has been distorted or stifled because of copyright and patent. Because, I mean, there's lots of things that happened in the past that we got away with because they happened too quickly without permission, like Uber. But, you had rap music doing sampling. You have documentaries that are produced, but a lot of documentaries are not produced because people know that it's too hard to get the permissions because of copyright. So you have a huge distortion of culture. I mean, you have Bill Gates being interviewed in the like 1990s saying that if there had been software patents at the time, that was kind of a later thing, then Microsoft could never have gotten off the ground, right? There's lots of early technology that got away with it, but now the way patent law has morphed and IP law has morphed, there's lots of things that are being strangled. We just don't know what's being killed off because that's the untold or the unseen costs of the state and unjust laws.
one other thing I was going to bring up as an aside. There's now a trademark that Ayn Rand Institute put on the name Ayn Rand. I guess they would try to argue they were protecting her reputation from people. I don't think it's enforceable or that they've ever even necessarily tried to enforce it.
Yeah,
But
trademark law is a little counterintuitive. It's the way trademark law works is the more descriptive a name is, the less enforceable it is because you can't get like a trademark on French fries or pizza because then you would be able to everyone have to come up with a different name. But if I make up if I call it cloud discs or something that's not descriptive and not accurate, then I can get that's why people come up with fanciful names like Kleenex used to be a name for tissue that's become generic because of overuse. Xerox used to be one.
our show's
Um,
called Ayn Rand Fan Club. It's like, are we in trademark violation?
that's so descriptive. It'd be hard to get a trademark on that unless you like had a famous aspect to it after a certain number of years of use. But that it would still be a very narrow mark. That's the way trademark works. But the odd thing about trademark is, unlike patent and copyright, um, there's almost a slight justification for being a little bit of a trademark bully in today's world, which has trademark law, which I would abolish too. But I would abolish every form of IP, some for independent reasons. If you wanted to rank them as far as the worst, it's patent is the worst, copyright's next, defamation law is the next worst, reputation rights, and then trademark, and then trade secret. That's how I
So
would
wait,
rank
you're
them.
saying you're against defamation law?
Absolutely. Yeah, because there's no reputation right. This is Walter Block and Rothbard have argued this, and a few other libertarians. But yeah, um, again, you can't have a property right in value or in the value of your property. You only have a property right in the physical integrity of it. So you don't have a property right in what other people think about you, which
So
is
you can
the
use your
problem.
printing press to disparage somebody. I mean,
Correct?
can
Yes.
you incite violence against them?
No, you can incite violence. That's a different thing. Chapter 8 in my book is about causation, and no, I think that if you incite violence, that's a completely different thing. So not all speech is free, actually. Like I don't believe in free speech. Like if your speech plays a causal role in aggression, then you can be liable. You know, if I say ready, aim, fire, and my firing squad kills an innocent guy, then I'm responsible. Or if I'm a mafia henchman. Um, if I give my underling in order to go kill someone, I think I could be responsible for that. But that's not because of
Fire in a
defamation.
crowded theater?
Well, that's a more complicated issue. I mean, Rothbard talks about that. That's more of an issue of property rights of the owner, like what do his rules permit. But I think in general, if you're in a place and you do something like that, and your words have a causal effect on other people's rights, then that could be something that's like a part of a tort or something like that. But that's got nothing to do with reputation rights, which
Disturbing
is
the
what
peace.
defamation law protects.
Uh, you've touched on Hoppe and you know Rothbard. Any thoughts on the recent rise of the Mises Caucus taking over the Libertarians a couple years ago?
Well, I was sort of part of that in the sense of I watched it from the side. Although I've been a libertarian since, 1982, basically. Um, I never was a member of the party until about 6 years ago when the Mises Caucus emerged and Dave Smith and Tom Woods and these guys joined it. I did vote for Ron Paul and people like that over the years when I voted. Um, but I wasn't a member of the party because I've been skeptical of activism. But I finally realized that, well, if you're going to have a party out there, and you're always going to have a libertarian party, even if it fell apart tomorrow, it would come again. It would rise from the ashes because you're always going to have someone who wants to use that name. You might as well have people that are actually libertarians, right, running as candidates, and I think for many years they had terrible candidates. They weren't really libertarians, and unclear messaging. So I figured let's have the Mises Caucus take over, and maybe they can at least make them have libertarian candidates and have a libertarian message. And so I joined, and I'm actually on their judicial committee now. And at that convention about 3 years ago, before I was on the committee, I helped the Mises Caucus draft a clarification of the principles of property rights and what aggression is. Um, and that's
You're
in there
like the
now, which,
Jefferson of the Mises Caucus.
yeah, on that topic, by the way, just a couple days ago, I released a brand new document. It's called the Universal Principles of Liberty. I wrote this in collaboration with some other colleagues, but it's a kind of systematic statement of libertarian property rights principles and ju principles of justice and principles of law. And I'm pretty happy with it. I don't think anyone's ever done anything like this before, and it's based upon sort of the more coherent, systematic understanding of property right, based somewhat on Rand's views, but more on Rothbard and especially on Hoppe and Mises and my own sort of development of it, which I had to clarify my own views on all this to sort out the IP issue. So, like, getting the IP issue under control mentally required me to, I think, improve my understanding of property rights in general. So I'm pretty happy with that.
Good. Is Is Millay an inspiration for ANCAPs and even the broader liberty movement?
There's a lot of controversy and debate about that. Um, Hoppe, who's my Hoppe, just in fact this morning I posted on his site an open letter where he and some others resigned from the board of Mises Institute Germany because they are giving a big award to Millet. So there's people like
Does that mean
Hoppe and
Walter
others.
Block can join the German group? No, I'm kidding. Yeah,
He probably could, yeah, yeah.
he was
So yeah,
ousted by Hoppe.
yeah, I know, yeah. So Hoppe and others are not happy with Millet. Um, Now there's other activist types who are doing the libertarian happy dance, and they think it's the greatest thing since sliced bread. It kind of like remember the when Ron Paul ran in 2008, and there was all these memes, and it was like it's happening, like, and they were like, oh, see you. Lou Rockwell was writing, see you at the inauguration. It's like, libertarians always get so excited about something. Then, but like the Randians, like my understanding is this crowd of people around Rand when she was writing Atlas Shrugged, they were also enthusiastic and they thought that when it was published in what 56, like as soon as it was published, within 6 months, the world would be objectivist and rational and free. Like this kind of youthful, naive optimism. I
It may
understand it, but
take that level of optimism to build a long-term movement. They used to laugh at the socialists too.
it may, but I'm a fan of being self-honest and not deceiving yourself for goals. But I like realism and I like to know where I stand. But the point is, people always get excited about something, and then 5 years later, it's gone, and they're on to the next thing.
I don't
Um,
think they quite understood like how ideas impact culture and how long it takes for an idea
Correct.
to take root.
Yeah,
That came later, I think, with maybe Leonard Peikoff.
I totally agree. I mean, I was until until maybe 10 years ago, I always used to say when I was younger that most people are decent people. They just don't understand basic economics. So if we could just have most people in the world read economics in one lesson, we would have a libertarian world. Like I kind of naively thought that. So our mission as activists is to persuade people to read that. That is so naive on several levels because number one, that's never going to happen. Most people don't have our interest in reading books and things like that. They have their other interests, so they're never going to read it. And even if they did read it, I don't think it might make the world better if more people were economically literate. But you would still have this problem of sort of the public choice problem, the prisoner's dilemma problem that we have, where once you have a state like we have now, even if we had um, even if we had everyone was an objectivist in America, I think you would still have a big status problem because everyone has a rational incentive to once Congress is in session and they're taking from A to give to B. Once that happens, you might as well fight with special interest lobbying to get your slice of the pie, and then it happens all over again. So the only solution is to have no state, I think, really, because otherwise you're going to have eternal squabbling over a sort of type of spoil system. Um, but I kind of think now that the only way to achieve liberty is the slow, gradual way of hoping the human race matures and gradually learns things by practical experience and osmosis and by teaching examples. So one example I like to give is um, uh, until the Soviet Union collapsed in 1991, everyone would say, well, it's either capitalism or socialism. One has some advantages over the other. Now everyone knows that central planning is not the way to go, right? They didn't learn that from reading books. They just learned that from seeing it collapse. But that's been a teaching moment. People have this wariness about central planning now and too much central planning. So
It's
that's a
starting to come
teaching
back
moment.
a little bit.
It's starting to come back. People are forgetting. That's the problem. People forget. But I'm hopeful that with AI and with technology and maybe post scarcity production of super wealth someday, despite the state, maybe we'll gradually become more liberal and more humane, less religious, less tribalistic, more individualistic, and we'll just sort of become more liberal or libertarian because we can afford it and we become smarter. I don't know. That's my only hope, but I don't think we're going to do it by being activists and preaching it.
Yeah, it's got to come from within to some degree. That's good. William, any final questions?
I have one more, but I don't know if it's going to be easy to answer, in a few minutes. But I want to ask you about this idea of forfeiting your rights because you hear people talk about murderers, like if you murder someone, then you forfeit your right to your life. And I'm wondering if you think that's like the proper way to conceptualize rights, because in my view, you have rights and you don't lose them just because you do something, criminal. What happens is like other people stop respecting your rights or recognizing them. And so the state says, well, we're not going to recognize your rights and we're going to lock you up and put you on trial
Yeah.
because we suspect you of this. Does that like mesh with your view of like the nature of rights and like how
I,
how they are
I
affected by when you commit a crime or something like that?
yeah, I think it's in a way I think it's semantics. I think it doesn't matter what word we use to describe that process, but basically if you recognize that there's a concept called the non-aggression principle, which is what Rand said basically when she says no man may start the use of
Initiate.
violence, right? So she's distinguishing there between defense or what I call responsive violence. So she's distinguishing between the initiation of violence against someone else and the response to that violence. So there's a moral distinction there, and there should therefore be a legal distinction and a normative distinction. In other words, some actions are justified and some are not that use force. Actions that initiate force are not justified, and actions that are in response to force are justified. Um, and likewise, the same with laws that are based upon that. So a law that prohibits murder is justified because it's basically sanctioning the use of force, legal force, or the community's force against the guy that's initiating force. But a law that puts you in prison if you don't go to war for the country, conscription, or if you don't pay your taxes, or if you don't show up for jury duty, or if you sell drugs or put the wrong drugs in your body, or if you're the wrong religion or whatever, those laws are unjust because they're the initiation of force against someone who didn't commit force. But what those laws recognize is that in some cases, if you use force against me, it's unjustified. It's aggression. But in some cases, it is justified. Like if I use force against you because you're trying to attack me and I'm defending myself, then you you don't have the right to complain about that use of force against you. So we have a distinction here. We're making a distinction. Someone has the right to complain about force being used against them, or they don't have the right to complain, right? If it's self-defense. And you can use whatever word you want to describe that. You can describe that situation by saying, well, that means that the invader has forfeited his rights. That's just a way of saying that the use of self-defense against him is justified. So I think that the use of force against an aggressor in self-defense and even after the fact for purposes of restitution or even retribution or punishment is justified. Whether you want to call that a forfeiting of rights or not, to me, is just semantics. I use that term. Randy Barnett, I reviewed his book, The Structure of Liberty, and he didn't want to use that word forfeit, but I said, well, I don't think it matters what word we use because the words are just describing our view about the justice of a given type of action. Does that make
Right.
sense?
Yeah, so just to tag on there a little bit, um, I view it as rights are contextual. Like, 'cause
Yes.
first of all, Ayn Rand says, like, we believe in objectivity, so values are objective, everything's
Yes.
objective.
Yes.
So that means that there's a context in which
Yes.
you have a certain right, and then there's a context where you don't.
Yes.
So as long as you're being peaceful and,
Yes.
not murdering people, you have these
Yes.
rights. But then
Yes.
the context changes when you murder somebody.
Absolutely. That's a good way to look at it. Another aspect of that is her quite good response to people that bring up emergency cases. Um, there are situations where, and John Locke and others recognize this. I mean, there's a phrase in the classical liberal literature called "where peace is possible." I mean, there's a presupposition that peace among people is possible, that cooperation is possible, that it's good to live in society.
There
And that's
need not
usually
be conflicts among rational people.
there need not be in most cases, but you can imagine cases where there is conflict. Like I don't know, I think Rand or someone came up with this idea of like, what if there's another species of vampires? Then there's no way that we can have a cooperation with them because their self-interest is to kill us, and ours is to kill them. There's now we can only fight. Like I mean, or if you have two people stranded on a lifeboat and there's only enough food for one, then there is no way. And by the way, these lifeboat examples are terrible because they're trying to poke holes in principled libertarian or objectivist things. But it's like, well, socialism wouldn't solve that problem either. I mean, you can come up with things where there's no good solution, right? There's a war of all against all in effect. And so socialism won't solve it either. It just gives a winner, it may choose a different winner, but it doesn't solve the problem. Sometimes you have, if there's two people in a desert and there's only one bottle of water, there's no way that they're both going to survive. It's just rights and normative thinking won't solve the problem. So we're almost in the case that Rand talks about at the core of her ethics, which is I think Rand's ethics is really hypothetical. So they don't like to admit that because it's an if-then thing. It's if you value life, then you should live like a man or certain things like that, right? It's hypothetical in that sense, but she would say that the choice to live is amoral or premoral because you can't say someone should choose to live because the should there is a normative thing that's based upon values. But if you don't value living, then there's nothing to rest that on, right? Although I think in her heart of hearts, just like me, I might admit theoretically that that I can't tell you whether you should choose to live or not. Once you choose to live, then I can tell you how you should live your life, right? Live like a man. But I think we would say, but you should choose to live, right? I think we all think you really should choose to live. That's what we really think, right?
You have to be alive to make choices.
Yeah, but we also think it's actually objectively good to be alive. So
Sure.
like if your friend asks you, "Hey, I'm thinking about killing myself. What should I do?" You wouldn't say, "Well, I can't tell you because if you choose not to live, there's no basis for me to criticize you because you haven't." It's like that's bullshit. You say, "Don't kill yourself, dude. Give it a
Yeah,
month. Maybe things will get better." Come on.
I
Life
think
has
any
value.
healthy person, tries to live as long as possible. If you value yourself, then you want to live, and that's just a natural choice.
They do, but Rand says that choice is premoral, or it's amoral or premoral. The choice to live is premoral. You can't criticize it based on morals because morals come from that choice to live, right? But it is, as a descriptive factual matter, it is true that most life is a process that exists for a reason. It wants to perpetuate itself, right? Yeah, a healthy person does want to live because they value living, they
Okay.
enjoy living.
Exactly. Well, this has been a great conversation. Depending on what legal things come up, maybe we can call on you in the future, but we'll put up a link to your website and to that new piece you referenced. And thank you so much for joining us. Um, I'm Scott Schiff along with William Swig. This is the Ayn Rand Fan Club, and we'll see you next time. Take care.